Good morning, everyone. My name's Nancy Davidson. I'm General Counsel for the League of Arizona Cities and Towns. And this is my first annual conference, so this is fun. And today's session right now is Development Incentives Post Schires versus Carlat. There are handouts for this session. They're on the League's website and on the app for the conference. And all the bios for our speakers today are also on the conference app. Also, if there are any attorneys in the room, I don't see any, but this session is CLE eligible. And if you would like to get credit, you just need to sign the attendance sheet at the League's registration desk, and they will give you the CLE form. There are other sessions that are also CLE eligible, so. Okay. I would ask that please guests to silence the phones or turn them off. And I'm not gonna put anyone on the spot like our keynote speaker this afternoon. But so today's session's about the most recent Supreme Court case in Schires versus Carlat involving the city of Peoria, and it came out in February 2021. The Arizona Supreme Court. Basically, the decision makes it more difficult for Arizona cities and towns to compete for different incentives and economic development. The panel today will discuss the decision, share maybe lessons learned regarding the gift clause and about the case, and we will talk about the future of municipal incentives and development agreements in Arizona. I'm not sure if we will have enough time for questions, but if you do have questions, I'm sure the speakers will probably be hanging around maybe a little bit, or you can reach out to me. And so our speakers today, we have Cameron Artigue. He's a member of Gammage and Burnham. He's an attorney. We have Carrie Kelly. She's Executive Director for Arizona Association for Economic Development. And we have Bill Sims. I'm sure a lot of you know Bill. He's an attorney for various cities and towns in Arizona, and he's with Sims Mackin, and he's also the legal advisor to the risk pool, so AMRRP. So we'll start with Cameron this morning. Can everyone hear well? Okay, good, awesome. Thank you.
Okay. Thank you. Cameron Artigue. I've been a lawyer here in Phoenix at Gammage and Burnham for 30 years. I've had the opportunity to talk about Schires versus Carlat 5 or 6 times to mostly lawyers who can bat this around in a kind of pointless and boring way for hour after hour because there are more questions than answers about this gift clause stuff. I am happy to be here with you this afternoon because I can cut right to the nitty-gritty and tell you what you need to know to talk in a meaningful fashion with your city attorney, to consider economic development proposals, and whatnot. Okay, let's do 110 years of history in 110 seconds. The gift clause is part of Arizona's Constitution. It was adopted in 1912 as a kind of anti-corruption measure, that you couldn't give money to your cronies. That role was kind of taken over by procurement codes, open meeting laws, that kind of thing. So by the time I started practicing law in the late 1980s, the gift clause was kind of an afterthought. It was kind of moribund. It was on your due diligence checklist, but it didn't matter a whole lot. The gift clause required, and still requires, 2 things. One, a government expenditure has to serve some public policy, but that can be anything, okay? That's easy. The second thing is a government expenditure has to be supported by adequate consideration, which is a fancy way of saying you have to get something back that is kind of proportional to your expenditure, okay? That's what makes something not a gift, is that you're getting fair value for it. But the thing was, for 100 years, courts would give great deference to the decision of local officials and say, we're not going to second guess how much you're paying for a city manager or a fire truck or construction materials. That's for you elected officials. That's for the staff. That's not for courts. And so it's only when something gets completely out of whack that the courts would get involved under the gift clause. And the point is that hardly ever happened. Okay, it was just a very low bar to pass the gift clause. Now what happened as you move into the 21st century is cities start to engage in more and more complicated real estate transactions. And you have, all of a sudden you're talking about incentives and rebating sales tax revenues and who's going to pay for the infrastructure and what deals can you cut on impact fees and how does this tie into annexation and the creation of jobs and the creation of tax revenue. And you've got 27 moving parts and this deal looks like it could be attractive for so many different reasons. I think I'll vote yes on it. And what happens is you get this legal question of what counts as consideration. If under the gift clause, you're supposed to say, hey, municipality, you've got to get fair value for this expenditure, well, what counts as fair value? And this takes us to a case I handled called Turkin versus Gordon in 2010, involving a development here in Phoenix. And the question there, and this is why Turkin versus Gordon's important, it draws a distinction between direct benefits and indirect benefits. Well, what in the hell does that mean? Okay, I'll explain it this way. Imagine you're buying a sports car. Okay, you go to the dealership, you say, I want to buy this $100,000 sports car. The dealer says, it's a great car, it's got this many horsepower, it's well made. Those are direct benefits. If you pay $100,000 for the $100,000 sports car, there's no gift, there's no problem. If the dealer says, hey, but if you buy this car, you'll have more status, you'll get more clients, your partners will think you're more important, it will improve your sex appeal. If that's why you should buy this car. And I say, yeah, damn, that's right. I'll pay $150,000 for this $100,000 car because of all those other reasons. Now, those may be legitimate reasons, but those are indirect benefits. Okay, and what the Supreme Court says in 2010 in Turkin against Gordon is that when you're measuring consideration, you can only count the things that the private party is promising to deliver as part of its contract performance. So if a developer says, I promise to open this factory or open this employment center, period, they haven't really promised you anything. If they say, I'm going to locate here and promise you that I'm going to create jobs and create tax revenue and I'm going to install a new arterial street and finish the stoplights, then those are promises. If you could sue them for breach, then it's part of their performance. So that's what Turkin against Gordon said. Now, fast forward to earlier this year, Schires versus Carlat. City of Peoria. A failed restaurant is to be redeveloped into a university, and the city basically gives the money to do the tenant improvements to rebuild the restaurant into a small university campus. And therefore, they can revitalize that use. The Supreme Court says, gift clause violation. The city's not getting anything for that, because all that's going on is that a private business, a university, is coming to Peoria and opening up its private university. There's no value being given for that. And the Supreme Court unanimously says that's a gift clause violation. So there's two important holdings. Let's finally go to the next slide now. There's two important holdings to Schires versus Carlat. The first is the Arizona Supreme Court says we're no longer going to give deference to elected officials in measuring consideration, okay? Now, it always was before that, hey, as long as you're roughly right, we're not going to second guess you. Now the courts are saying, and they're supposed to make their own independent valuation of what a municipality is getting in exchange for its expenditure. This is a big deal. Because what you've all done it, those of you who sit on elected bodies or on staffs, all of you have seen this, where, council wants to do something, you hire a qualified consultant, they do a good report, they come to a council meeting, make a presentation, it's persuasive, questions are asked, maybe they go take a look at something else, and it's approved. And you say, well, who could argue with that? We had a qualified person tell us this was a good idea. That's the basis for our decision. And that's always mattered a lot until now. Now under Schires versus Carlat, the court says, oh, we don't care if you had a good basis at your council meeting. We're going to decide in court whether the consideration was sufficient, without any deference to the local officials. So that's a very big deal, because it sort of shifts the kind of expert dispute out of a city council setting and into a courtroom. The second holding of Schires versus Carlat, holding number 2, this is where you could walk around this conference and get very different opinions from the attorneys who are attending here. What counts as consideration? Okay, now if you go back to Turkin against Gordon, supposedly consideration includes everything the private party is promising to do in the contract. Well, in answering this question, the Arizona Supreme Court did like the scarecrow in Wizard of Oz. They pointed in both directions. And on the one hand, they said, hey, this university didn't promise Peoria anything, and therefore there's no consideration, which is just just restating Turkin against Gordon. It implies that if the university had just said, hey, we're going to have administrative staff, they're going to have jobs, we'll pay them, we're going to pay our faculty, we're going to sell food and beverage, so you're going to get tax revenues, you're going to have jobs created, and we promise you that in the contract, that would have sufficed. And there are lawyers attending this conference today who charge obnoxiously high hourly rates, who would say that that's the true meaning of Schires versus Carlat, that it was just a drafting mistake, it was just bad lawyering. And if the university had just said, hey, yeah, we promised to create some jobs, that the case would have come out differently. And the Goldwater Institute, in one of these deals I did with them, they said, oh yeah, a promise to create jobs counts as consideration, as long as it's in the development agreement, that counts. Okay, that's one view. The other view is that the promise by a private business to operate as a private business, period, just can't count, never can count. And the court said in a passage that that would be like a hamburger stand saying, hey, we'll come open our hamburger stand in your jurisdiction and sell delicious hamburgers. Will you give us an incentive to do that? And the Supreme Court said, if you let cities pay for that, it eviscerates the gift clause. Because if you can just say, hey, we're going to pay somebody to come open up their, then why not pay dentists and lawyers and anybody to, we'll pay people just to move here. And that is a gift. Now, if that's what the Supreme Court meant, that's a huge deal. Because it overturns the assumption on which a lot of economic development activities go on. Now, we don't know the answer to this question. So it will take a next case to respond. Okay, let's go to my last slide. This is the sort of the stuff you paid for, what you can do to deal with this uncertainty. What's your toolbox for responding? Point number 1, don't be a hamburger stand, by which I mean in any deal, have the private party do something that goes over and above just opening up their shop, okay? It can be giving local citizens a discount. It can be giving local citizens preference in hiring. It can be promising to create jobs. It can be participation in some civic activity, something. But in case somebody says, hey, aren't you violating Schires versus Carlat? You say, no, they're promising to, sponsor the Little League team and give free dessert to residents on every Thursday. And, so don't just be a hamburger stand. You have to do something over and above what naturally is done in the course of operating your private business. Infrastructure, use infrastructure. Schires versus Carlat, allows cities to construct infrastructure because the public body is still going to own it. Now, there's a constant debate, and I represent a lot of developer clients on the exactions and dedication side, where it's like, hey, we'll approve this development proposal if you'll build the arterial street, if you pay for a stoplight, and that's fair. That's all nexus and proportionality, Nolan and Dolan, cities can do that. But they don't have to do that. And if a city says, you know what, we'll pay for the stoplight out of our CIP, that's not going to be a Schires versus Carlat problem. Because for a city to spend money on its own publicly owned infrastructure is just different than, it's not a gift, because there's no money being transferred to the private party. The center points there, center of the herd and the benefits of complexity. This is just the point of, you know what, in the 15 years we've been talking about the gift clause in this state, there's been like a half dozen of these lawsuits. So, 99% of them are done without a court challenge. So just don't put yourself on the edge of the herd. Because if you do something that's in the middle of the pack, you're going to be safe. So tell the private party, if you're representing the municipal side, don't get greedy, don't paint a target on your back. Let's do this in a way so it goes down the middle of the plate and doesn't create a attractive target for a lawsuit. Special district immunity, this is a sort of a bonus point. You can dazzle your city attorneys with this. Special districts are immune from the gift clause under the Arizona Constitution. Your drainage districts, your fire districts, all those special purpose tax levying public improvement districts, for reasons I don't know, but they're all exempt from the gift clause. So if you can figure out a way to utilize them in creating some kind of transaction, you can write the gift clause completely out of the situation. Turkin footnote 4. Footnote 4 of the Turkin opinion says that the gift clause doesn't, this is a weird way to say it, but the gift clause doesn't apply to gifts. Because when we were doing the Turkin case, we agonized over, what about the Phoenix Symphony? What about the zoo? What about the money that we give to boys and girls clubs? Is that a gift clause violation? And the Supreme Court said, oh no, if you're giving the money away, the gift clause is not a problem. It only applies to contract-like transactions. So, if you're doing something that is kind of in the nature of a public welfare, obviously, public housing, that kind of thing, you don't have to worry about the gift clause. So, and then finally, my final point is legislative change. This is the Constitution, remember? So it is, you can't just run a bill to fix this. To amend the Constitution, you would have to have a public vote. And you're just not going to get this on the ballot. You're not going to get a constitutional amendment to loosen up the gift clause. But there may be ability for the legislature to do some things in a way that unites the caucuses, both caucuses out of the legislature. My idea is to put a short clock on gift clause challenges. That you might be familiar with from annexations. When a municipality annexes property, it's 30 days. You got 30 days to go to court. If you don't go to court in 30 days to challenge the annexation, done. And you're barred at that point. Same thing with a referendum. 30-day clock after legislative action, done. And I think you could pass a statute that imposed that kind of clock on a gift clause challenge. because you can't just when you enter some big complicated development proposal, you just can't wait around for a year, to see, well, is somebody going to sue? When can we start the permitting process? So I think there might be a bipartisan interest in putting a short clock on this. I will sit down with that. Thank you.
Thank you, Cameron. And next is Bill Sims.
We each have 20 minutes, so we're going to do our best. The reason Cameron represents private sector clients. I am a city attorney for 9 cities and towns, and I work with the risk pool, and I work with all 77 risk pool members on land use. I'm here to help you understand the gift clause, because I bet many of you as elected officials have been told by your city managers or your city attorneys or town attorneys, the gift clause, we can't do anything. And there was much haranguing as a result of Schires as to whether or not it would grind you to a halt. And thankfully, you at the local level have succeeded. You have done very well responding to the countless challenges your communities have had to face. And it provides a good sort of microcosm to analyze some of the things that Cameron talked about as you are now charged with implementing the visions of your constituents. Bottom line is the system worked. Let's learn what happened, and let's see what that means for the gift clause. Well, first of all, I can remember about 15 months ago, CARES Act monies were coming out, and it was going to be used for giving away money to your constituents. Well, the Constitution says you can't do it. It says, city bans any donation, grant, or subsidy. Here's the words in the Constitution, that second bullet. You can't make any donation or grant by subsidy or otherwise. I've had managers in this room call me, say, I want to give money away. And I go, well, the Constitution says no. But guess what? We found ways around it. And the question is, how could you deliver grants to your citizens when CARES Act or the Rescue Plan Act says, here are grants, give the money away, and the Constitution says you can't? And you have some really good city and town attorneys, and Nancy's been very helpful from the league to figure out how to do that. The first is, and Cameron mentioned this, and there's going to be a couple times when I have to give a compliment to our Attorney General. He issued 3 AG opinions that were very helpful during the pandemic. The first one focused on what Cameron talked about. The gift clause does not apply to non-contractual public expenditures such as direct assistance to the needy. Now, Cameron and I have debated the impact of the gift clause. I think it's much easier for you and me as working for cities and towns to help the needy. It's much harder to say Walmart is helping the needy. Cameron represents the Walmarts. But the point is, he has a tougher hill to climb. You don't. And that's the point of these slides and how you can best take the money that the federal government is giving you and get it out. Under this AG opinion, remember Cameron said there are 2 prongs to the gift clause? Public purpose and consideration. What this says is, if you're supporting the needy, if you're promoting economic welfare of your constituents, you never get to the consideration. So we don't have to do the mind-numbing math. The 2 biggest problems of Schires, Cameron mentioned. One is they took discretion away from you, the elected officials, and 2, they applied a rigorous mathematical analysis to the consideration that we need to try to avoid. But the question is, this opinion was issued 2 weeks right at the same time that Schires was issued. Does it survive? I think it does. Here's what you have to do, and Cameron mentioned it. I want to make sure I stay on time. Turkin v. Gordon, the case he talked about, and the Schires case, both say you can do this, but only under limited circumstances. There's a case out of Tucson, the University of Medical Center. A $50 million asset was rented for $10 a year. And our Supreme Court said, and this is quoted in Turkin, that public service, when it's in a contract and it's required by statute, is a way to avoid all of the gnashing of teeth about what Schires means. And so what I say to my cities and town councils is find a public purpose, find a statute that authorizes it, and then document the benefits. That is the moral of the story. Put it in a contract and find a statute. When Cameron said the poor drafting, the issue there was, I truly think you can satisfy Schires if you say to a developer, give me some meaningful benefits, give me a remedy that I can sue you on, so I can show that court that this is a promise you're making, and I think you can survive Schires. Now we've looked at what the laws are. Now we have to look at the funds you're going to be spending, and there are really two categories. A year ago, we were dealing with CARES Act funds, and it was very flexible, a lot of flexible options for you, mostly for public health and safety, and this was an answer that the state gave you. We're going to talk about it in a few minutes. Once the local jurisdiction has reimbursed the previously incurred public health and safety costs, you're free then to deploy all the local resources. What that's saying is, backstop, fill in the backstop, go ahead, you spent some general fund monies on public health and safety, now let's take CARES Act, pay yourself back, and what that says is you can spend it almost on anything. And I don't think the state had that power to, in effect, rescind the Constitution. And I can remember the former league president, Mayor of Maricopa, I was working with his attorneys as we were trying to draft a memo. We really loved that provision, but boy, it really does violate the Constitution, but there's a case. This is a case that involved ADO, the Department of Administration, refused to honor checks that were cut by DES. DES was using federal funds, and ADOA said, well, no, you're a state agency, and guess what? You have to satisfy all these budget requirements. DES said no, took them to court, and this is the very helpful language. I've given this talk to your city and town attorneys. This lets you make grants. What it says is only money raised by the operation of some general law becomes public money, but it's that second bullet. Public funds refers to funds belonging to the state and does not apply to funds that are simply held as either a custodian or a conduit, meaning the federal government provides the funds. As long as the federal government provides the funds, you can avoid the restrictions of the Constitution, because that's what this case says, is we'll follow federal law. But the problem is, are there strings attached? If the federal funds come clear to you, you're fine. Under CARES Act, the larger cities got the funds directly. So there was no ability for the state to infect those funds with state requirements like the Constitution. But CARES Act, through the governor's office, also went to smaller jurisdictions. And here was a question that they were asked by a local jurisdiction. What if I want to use these funds to support small businesses, nonprofits, arts, and other types of activities? This is the question to the state. The purpose of the CARES Act fund is to provide local jurisdictions as much flexibility while not duplicating other federal streams. And this is what I read earlier. Once the jurisdiction is reimbursed the previously incurred public health expenses, they're free to deploy the revenues. I don't think that satisfies the Constitution, but that's why that case, the DOA and DES case, helps us. But the problem was with CARES Act, remember, they had two categories of recipients. They had the large cities getting the money directly and the smaller cities getting the money. And when you go back and read that June 2020 set of FAQs from the governor's office, there were like 14 different requirements that the governor was imposing on funds coming to you, the smaller jurisdictions. And does that render the funds no longer conduit funds? Funds that now the local small jurisdictions are stuck with the Constitution. And I can tell you, it was hard to explain to some of my clients why they were a smaller jurisdiction and why they had to satisfy the Constitution. They couldn't give away the money for business incentives because they got the money through the governor's office, and there was an argument that they lost the conduit status. Well, the Recovery Act, the rescue plan helps us. And Nancy put these on the website for the league. They came out with a long series of FAQs that are very, very helpful. But again, the Rescue Plan Act does continue this dichotomy by treating large jurisdictions different than smaller jurisdictions. I am the city and town attorney for 9 smaller jurisdictions. And for those of you from the larger jurisdictions, we do have a sense of relative deprivation. It's not odd that our legislature why is it they refer to the smaller cities as non-entitlement cities and the larger cities as metropolitan cities? That double standard under CARES Act was fatal. Because remember, the smaller cities got their money through the governor's office with 14 different requirements and lost the conduit status. Now we've moved to the rescue plan. Regrettably, the smaller cities are still called non-entitlement cities, and they still get their funds through the state. But that's why that Navajo Tribes case, the DES case, is so important. You have to preserve the conduit status. And that's how the rescue plan helps us, because it has much stronger language that prevents the state from imposing requirements. Hard to read that. What it says is there's guidance for the non-entitlement units. States may not place additional conditions or requirements on those non-entitlement units. States may not impose stricter limitations than permitted by statute or Treasury regulations. That is a home run. That is how the local jurisdictions, the quote non-entitlement units, are able to take the federal funds and do all sorts of things with it that are allowed by the rescue plan, and we're going to walk through them. Here is what they allow. And let's go through these. If we were stuck with the Constitution, you couldn't do many of these, but we'll go through them. Responding to COVID health emergency, clearly permitted under the Constitution, therefore we can do it. Assisting small businesses and aid impacted businesses, travel and tourism. Boy, I don't think you could do that under our Constitution. But with the Recovery Act, it says, you, the state, can't impose any requirements. Therefore, I believe you can take the ARPA funds and use them to promote tourism. You can assist nonprofits. I even think under the old rule you could without the conduit theory. Remember, we're preserving the conduit theory. We're taking federal funds and using them for things that otherwise couldn't be used here in Arizona. Provide premium pay to essential workers. I'm not sure you could do that without the conduit theory. Provide grants to employers of essential workers. You can give direct cash to households. I had mayors calling me and say, I want to give money. And unfortunately, until we got the ARPA, until we had the conduit theory, I said, boy, that runs against the Constitution. Back to work incentives. Read the FAQs that Nancy put on the website. You can actually use funds to provide travel for folks to go to job interviews. I mean, that's where the federal government is reaching out to help us. And by preserving that conduit theory, by making sure the state doesn't impose requirements, you're liberated and can use them for these funds. This I think is clearly constitutional. Make up COVID-induced revenue shortfalls to your governments. And as Cameron pointed out, one way to avoid the constitutional restrictions is put it in infrastructure. And I think I'm going to do this in 20 minutes. Does this help? Now by following ARPA, does it help you justify? Yes, I think it does. The ARPA restrictions, those two sentences that I read to you, that this is the federal government saying the state can't impose any requirements whatsoever, preserves that conduit theory, and lets you do all sorts of things like writing checks to businesses, like giving people money to go to job interviews, like paying nurses more money with now state funds, federal funds that you're merely a conduit for. But what happens if that fails? What happens if the Goldwater Institute says Sims is wrong? We have a state constitution, and we're not going to let the federal government gut our state constitution. So if that's the case, then you're stuck trying to argue supporting the needy, which I think is a good argument. It really is helpful for us. As I said in one of the earlier slides, find a statute, put it in a contract, create obligations, and sue them on them. Or, if all that fails, no longer a conduit, we're not supporting the needy, we're helping Cameron's Walmart client. What do? All is not lost. As Cameron pointed out, the Schires case defines benefits as indirect and direct. Historically, and this is why we government attorneys were wringing our hands. Historically, you would usually, the statute is 9-500.11. I have no life, I know statutes. But that statute is the one that says you can give away sales tax as long as you keep more than you give away. Schires gutted that, unless we can add some. What they said was, go ahead and do that for the public purpose. Go ahead and show that you're getting more taxes than you're giving back. But then you have to document indirect benefits. And there you don't have to show a 5149. There's some case law that suggests if you can just get 80% to them and 20% to you and find benefits, and Tempe is doing one now. They're doing it where they're, let me see if I can find it, where they're looking at the indirect benefits and they're quantifying the indirect benefits and they're going to sum those up. And those benefits don't have to be 5149. They just have to be 20% of the amount that the developer gets. So what are the lessons learned? The AG has been a big help. He came out with that gift clause that we talked about, supporting the needy. He came out with an opinion that backed Pima County and confirming that you, the mayors, have an independent right, and county chairmen of County Board of Supervisors, to issue orders and prevail over the governor. That's important. If the governor tries to impose restrictions and undermines the conduit theory, you, relying on this AG opinion, can go and impose requirements to make sure the conduit theory is, and I have a number of mayors from my cities and towns are here, and I must commend them for what they have done during the COVID environment, as they've done things that really were profiles in courage and requiring face masking. And you all have done this with limited guidance. I can remember when this first started. I had one mayor who was on the committee for a rodeo that had been there forever, and he's also the mayor, butted up against a jurisdiction that required masking, so all of them were coming in his jurisdiction. He canceled the rodeo. It had never been done before because he was worried about public health. And the risk pools, I work with the risk pool, we really have mobilized with Nancy and tried to help all your attorneys. Take advantage, I left off one AG opinion, the other AG opinion. He came out with a really good opinion that helped you have your meetings virtually. It's real hard to have a zoning hearing because property owners have a right to a hearing. I'm so impressed when I saw what you all did. People were putting screens up outside the council chambers so that people could sit there and watch, and then they'd come in at the appointed hour or minute, appointed time to participate and have their hearing as required by the Constitution. Make sure if you have an ordinance, if you, the mayor, are going to exercise powers, and as the AG says, powers are prevail over the governor, you need to have that in your ordinance. You can't make it up after the fact. This is in the FAQs that Nancy put out. The federal government is saying, we're going to let you make grants. We're going to let you pay for that ride to the job interview. But when you do that, do it on a fair and equitable basis. Because some of the opinions that Cameron talked about says if there's an inordinate amount paid to one private party, that could be unconstitutional. That also helps you politically. If you're going to start doling out funds, you got to make sure you dole it out fairly and you're not just helping one small sector of your city. And then finally, call the league. Nancy has been an unbelievable resource. She sits at the hub of all this information coming, and she gets it out to all us attorneys. I can't believe how fast she does it. It's almost real time. And that's what we've done during COVID. As we've tried to help you, the mayors, and you, the elected officials, respond to your community's needs, read through all this law, figure out what to do, try to explain that Schires isn't fatal, Nancy's been the one helping us. But you do have to address Schires, and Carrie's going to talk about it. This is a quote. This is why we started down this path with city attorneys. This is what the GPEC said. They were talking about the case. The ambiguity in application of the decision has caused cities to take a wide variety of approaches to incentives, including not offering them at all. That move kneecaps Arizona, cities and towns trying to compete with cities in other jurisdictions. But the moral of this story is the sky is not falling. Don't let the gift clause freeze you into inaction. Rely on the conduit theory and make sure you're using federal funds, and go read the FAQs. I can't believe how much you're allowed to use, what you're allowed to use those funds for. But if all that fails, try to argue supporting the needy. And if that fails, then you're stuck with the benefits and trying to figure out ways to have indirect benefits that don't just rely on sales tax and jobs. And then that's the indirect benefits. Make sure it's in a contract. Bottom line, the pandemic has been a crucible. It has allowed you, local governments, local elected officials, to show that government works. Some of you attend the annual conference training that I do for elected officials. When I walk through and I have quotes from Jefferson, Adams, Franklin, and I bring it all the way forward to Reagan and Kennedy, and I talk about how our founding fathers wanted government to work. I'm not sure it works very well at the national level. I can tell you the pride I have in working with the mayors in this room. It works at the local level. Risk pools have pitched in. For example, we had one jurisdiction call. I think I'm more okay. One jurisdiction call, and the Department of Homeland Security was dumping for persons they collected at the border in their jurisdiction with no protection. And so that's one city and town pool. The administrator called this other pool of 600 social service providers. We got buses to that jurisdiction. It was Gila Bend, and they were able to take these undocumented persons to a church where they could get shelter. That was an example of risk pools helping your communities. And we, the city and town attorneys, we're not elected. We work for you. Our job is to help you carry out your vision. It's amazing with Nancy as she's guided us with the data, how we, the city and town attorneys, have tried to help you. Good luck.
Next, we have Carrie. Bill is way too kind. Usually when I have a question or I don't know, I call Bill. And so he gets a lot of phone calls from me.
Those are a hard act to follow, but I also love being in the middle of two attorneys. I spent 14 years at a law firm, so I feel like I'm right at home here. Hello, everybody. My name is Carrie Kelly. I am the Executive Director of the Arizona Association for Economic Development. For some of you that don't know, we're an organization of practicing economic developers, those in the private sector who touch on economic development, elected officials, and community leaders that care about economic development and the future of Arizona. And I'm very happy to be here today to present to you. Hey. We've had a wonderful overview of the gift clause by our wonderful attorneys, and now I want to look at how all of this affects the practice of economic development. And what I really want to do is start with business attraction, because that's what we're really talking about, and why a business locates in a city or town. Arizona's competitiveness with other states and internationally really depends on the industry sector. For example, if we're looking at manufacturing, we may be competing with states in the Midwest. If it's aerospace, it may be the Northwest. And we're not always competing with Texas, but a lot of the times we are. As a state, we have attraction focus in aerospace, technology, manufacturing, bioscience, film and digital media, and business and financial services. And what a company looks for when they locate into your city or town is typically the first thing they look at is the cost of doing business. And that's typically always number one. But also some of the things they look for are access to a labor force and transportation as well as a lot of other factors. One other factor I've coined is the Indiana test. And I'm only allowed to say this because I'm from Indiana. But Indiana has a similar cost of doing business, has access to transportation, has a labor force, but Arizona has one thing that Indiana does not have. Does anybody know what that is? Yes, the climate here. We have sunny weather compared to what Indiana is, and that is actually a factor in businesses locating here. So it really takes sort of a whole spectrum of things to have a business locate in your area. One of the other things that we're starting to see from site selectors are the social issues. Things that have just come up in the last year and a half are whether your police are being funded, if there's plans to defund your police, and also if your cities have an inclusivity ordinance in your city itself. So these are things that we've never really seen as economic developers before, but that are coming up in site selector questionnaires. I also want to say to this audience especially that really being mindful of creating sustainable quality communities, that cannot be discounted. And I think a lot of that starts with the Strategic Economic Development Plan. So please go back to your communities, see if you have one, and if not, it's something that we can help you find the funding for and to develop one. We all need to be planning for our futures, and all of this comes into play when we're talking about business attraction and our competitiveness as a state and cities. Slide. So next I want to talk about the landscape of incentives and economic development across Arizona. The practice of economic development looks very different in different communities. I come from more rural communities, and what we do is typically more community development. We're working with our nonprofits and local leaders to build up nonprofits and volunteers. We're looking at small business development, downtown, Main Street sort of things, versus what you would see perhaps in the city of Tempe, where we're looking at that in addition to bringing in large companies to the area. So it looks very different. But even in our rural communities in Arizona, we still are looking at incentives. We have smaller communities that have tax creation incentives and other kinds of local incentives that they use. Right now, there's also a really big focus on business attraction. So we have sort of at the state, the ACA, we have GPEC, we have Sun Corridor, we have a lot of local economic development organizations and municipalities that are dealing with business attraction. And right now, we're sort of adding a lot of economic developers because we're seeing a lot of people come in from California, from Pacific Northwest that we've never seen before, from the Midwest. Like Arizona is the hot place to be in. It's awesome. And you guys have done a really good job of building up your communities to make that happen. So before this case, economic developers could really rely on the fact that they were bringing in businesses that would increase the tax basis, create more jobs, and packages could be produced and approved by you based on that. But that has really gone away, as you've heard. The ruling took away communities' local control in determining what is best for their communities. And unfortunately, that's really handicapped your communities and our economic developers' ability to provide the best attraction packages for businesses. Immediately when the ruling came down, we had cities that were in the middle of deals that stopped those negotiations, stopped those deals. We had the league, ourselves, a bunch of attorneys trying to figure out what the ruling meant and how to move forward to structure deals. And I have to tell you, we're kind of in the same boat that we were. We're all still trying to navigate and figure it out. What we do know and what's safe are incentives that are tied to job creation, first and foremost. Infrastructure, as was discussed, infrastructure improvements and those kinds of benefits, very safe. And then, of course, we have our state incentives. So we have a local package, but we also have state incentive packages that we can draw from as well. So we've had a few of our larger communities continuing to move forward on incentive deals. And I will say those are probably the ones that are a little more isolated from lawsuits. While we've had others that have completely stopped what they're doing because they don't want to be the next community that gets sued. So there is that fear among economic developers. And this has made our jobs a little difficult, but there's also opportunity for advocacy. We've certainly heard from the attorney's perspective what can be done to structure those deals in the best way, but as economic developers, we also need more tools. You know, I hate to say that a legislative fix is the only fix for this case or this ruling, but certainly there can be something that we can do at the next session, hopefully, or beyond, that helps us to deal with some of these repercussions that we're seeing from this case. So if we want to maintain competitiveness in the future, we definitely need more tools in our toolbox. So how many people here love job creation and creating a strong local economy? Yes, wonderful. So I did want to mention that AED as an organization has a professional economic development for elected officials course. We do have the basic economic development course. That is offered by us and the IEDC, the International Economic Development Council. That is really a deep dive on economic development in Arizona. We learn everything from incentives, business attraction, business retention, huge during the pandemic, and all these different things that play into economic development. And it's not just for economic developers, because all of you know and probably want to learn more about economic development. And we're offering that course in January. We also have an AZED Pro certification that's not just for straight economic developers with classes in taxes and incentives, business attraction, and we have a workforce development one coming up on September 29th. So part of what we do especially is education of you guys, education of the community and of our economic developers. I think, there's always a way forward and we're gonna figure it out. We are luckily in a really good place. Our economic developers have sort of met the challenges and we're moving past that, and certainly with the attorneys' helps and with the league's help, it's gonna be okay. So thank you so much.
Thank you, Carrie. We have about, I'd say, 5 minutes. If anyone has any questions, there's a microphone, I believe, yep, right here. So I don't know if anyone has any questions, but just also as a reminder for if there are any attorneys in the room, I saw a couple walk in late. You can pick up your CLE certificates at the registration desk. You need to make sure you sign the attendance sheet. Also, Bill mentioned several materials. I'm not sure if everything is on there yet, but I will make sure that everything that was mentioned, whether it's the Navajo tribe case or the ARPA information, and I'll make sure all of that is on the website. So are there any questions? No. Wow. See how everything was so informative. So thank you so much for oh, we got one. Perfect.
So, thank you, guys.
Thank you.
What about if we have a sports team that is struggling because either we don't have enough hotel rooms, or the hotel rooms are too expensive, or we don't have enough housing to house the players? Is any of that, because they bring in tourists to watch them, is any of that qualified in the COVID money?
It'd be a challenge because I'm very hopeful. All of mine depend on COVID, and COVID hopefully won't be here forever. So once it's gone, everything I'm talking to you about on conduit is lost. But you're asking. There are other, and Cameron mentioned this. There are districts that aren't subject to the gift clause, and that's how Chase and Bob was built. Because they're not subject. We were sued. We were sued by the New Times, and the Title 48 districts are not subject to it. And you asked about housing. A housing authority is not subject to the gift clause. So, what city are you in, or town are you in?
Prescott Valley.
I know your attorney quite well, and I think he has great ideas. There's ways you can do just what you said, not necessarily with COVID, because that's short-lived. But go read. Nancy should put those FAQs are unbelievable. They answer all the questions that she and I had a year ago. I think everything you just asked about, you could do with COVID. But you're not going to have a long-term financing solution based on COVID.
No, I understand that.
But you will, using a Title 48 district and using a Title 36 housing authority.
And then my second question is, we're going to purchase a building from the county, a large building, that we want to turn into activities for our youth, for sports and drug awareness and homeworks and all that good stuff. Does that qualify?
Yes, it is, but again, it's short term. And there's other statutes. Right. There's other statutes that expressly allow cities and counties to work together and having an IGA that do just what you said.
Just to purchase the building?
Yes. Oh, yeah.
Thank you.
Great. Perfect. Well, thank you very much, everyone. I believe your next session will be starting, is it 2:30? I don't know if anyone's here, but okay, perfect. Okay, well, thank you so much for joining us today. Have a great day.